perhaps last. This is the first session for Monday, December the 9th, 2019. First appearances in courtroom 1 of the BRC. This is Judge Kirkland presiding, appearing on behalf of the Office of the State Attorney.
Elaine Fusco.
And appearing on behalf of the Office of the Public Defender.
Manuel Soto Diaz.
Thank you. The first case to be reviewed this morning is Deandra Antonio Jackson. This is Deandra Antonio Jackson.
Your Honor, can we just skip him for a second and go to Michael Jernigan?
Yes.
Okay.
This is State of Florida. It's Michael Leon Jernigan. This is an arrest affidavit from December the 7th, day before yesterday. The arrest took place at 31 Deacon Jones Boulevard in Eatonville, Florida. The charge is a felony charge of grand theft, third degree of a motor vehicle, with a bond of $1,000. The public defender is appointed to represent Mr. Jernigan on that charge. He is to have no contact with anyone that's named as a victim or witness, and he's not to have any contact with a person that is listed as a co-defendant, that person named Chris Lamar Harmon. That no contact has to do with the time as long as this case is active and pending. Stay in touch with your attorney. The particular vehicle listed as a silver 2014 Lexus ES350. And the location of the event that's the subject of the case is North Wymore Road and East Kennedy Boulevard. Stay in touch with your attorney so that you know when to come back if you are able to bond out.
Yes, sir.
This is Mr. Jackson, Your Honor.
All right. This first appearance was reset from yesterday. Judge Hal Epperson was handling the weekend duty. This is a first appearance. I have an arrest affidavit before me that indicates it is from day before yesterday, December the 7th. An arrest took place on West Fairbanks Avenue in Winter Park. Count 1 is burglary of an occupied structure but unarmed. It's a bond of $5,000. Burglary of an occupied structure, $5,000 bond. Count 2, a felony, a misdemeanor of petty theft, $100. Total is $5,100 bond. It's from 229 West Fairbanks, which is a store called All Fired Up. The public defender is appointed to represent Mr. Jackson. The division is, it's Thomas Young is the division. The number for Judge Young is 14.
Thank you.
There is one condition in addition to the bond, is no return to that location of 229 West Fairbanks while the case is pending.
To this mic right here.
This is Leon Akeem Wright.
He refused, Your Honor.
All right. I have an announcement concerning Mr. Wright. The charge that's holding him is a new charge of trespass in a dwelling after warning. It's a misdemeanor, bond $500, and it's case number 19 MM 9838. He's also being held because he was previously in jail for trespass, a first-degree misdemeanor of refusal to leave on September the 28th, and he was released on December the 5th. That case was 2019 MM 7984. I take action today on that prior case. I revoke the bond in that prior case. He has the public defender in that case. And out of an abundance of caution, I'm going to appoint the public defender on the new charge as well. But because they are both misdemeanors, there will be a new bond on the prior case. The new bond on the prior case is the same bond that would occur if it was alleged that he missed a hearing, and that would be a bond of $2,000 on 2019 MM 7984. So his bond now is a total of $2,500. I'll reschedule him for tomorrow to see if he can be seen for a meaningful first appearance.
Your Honor,
Yes.
would you consider, reconsider the action taken on the prior case in 19 MM 7984? Mr. Wright was deemed incompetent to proceed, and he was released on conditional release, so I don't know if that is a consideration that would change how you treat that case.
It would not change it today, but it can be raised again as soon as he is seen at first
Okay.
appearances.
Thank you.
Stephen Lamar Coley.
Yes, sir.
Good morning.
Good morning, sir.
This is a charge of trespass and a conveyance from yesterday, December the 8th. It comes from 330 Lewis Court. That is in the city of Orlando, and it is the Orlando Police Department, but it is a state charge, a misdemeanor charge of trespass and a conveyance. And the correct address may be 3300 Lewis Court. It is shown as 330 Lewis Court on the front, but 3300 Lewis Court in the body of the narrative of the arrest affidavit. So I believe that's the correct, more correct address. The public defender is appointed to represent Mr. Coley in county court. This may be a case in which the state is making an offer to resolve the case at first appearances.
It is a pleadable offense, Your Honor.
Yes, Your Honor. Adjudication of guilt, 3 days with credit time served. Court call, no return to the scene of the trespass, no contact with the owner of the conveyance.
It may be necessary for you to actually speak into that microphone when you're giving that, so that the tape picks up your words. I can hear them, but I predict that the tape's not picking those up.
Yes, Your Honor.
Your Honor, Mr. Coley is going to accept the state's offer.
Thank you.
So 3 days.
Thank you.
Okay, thank you. Thank you.
Mr. Coley, what's your full legal name and your date of birth?
Stephen Lamar Coley, 412-6L.
Did you say April the 12th?
Yes, sir.
Thank you. The charge before me is trespass and a conveyance, meaning in a vehicle, in this case. at 3300 Lewis Court from yesterday. How do you plead to that charge?
No contest.
Did you have enough time to decide what is best for you?
Yes, I did, sir.
Did you have a chance to talk with your attorney about your options today? You can bond out or you can enter a plea. Did you read and understand your plea form?
Yes, I did, sir.
Do you have any questions you want to ask me about this charge or the facts of the case, the plea that you're entering, or the proposed sentence?
Yeah, well, you ain't got to worry about me going to the house no more. I know that. Yes, sir.
All right. Are you satisfied with your attorney?
Oh, yes, sir.
I accept the plea at this time. You are adjudicated guilty of trespassing a conveyance. The sentence is 3 days, credit for 2. Ordinarily, that means you'll be released later on this afternoon.
All right,
But I
thank you,
do order you not to go back to that location of 3300 Lewis Court in the city of Orlando during the next 179 days.
Yes, sir.
Your court costs will go into a civil judgment. That means that you do owe that, but it is not connected with this case.
Yes,
This
sir.
case is concluded when you are released from jail,
Yes, sir.
other than the requirement of not to return.
Yes, sir. Thank you. Oh, hold on.
The next case is State of Florida against Van Brown.
Yes.
Thank you. This is a warrant from Circuit Court. The warrant refers to a period of time that involves December the 1st of 2019, December the 2nd, December the 3rd, December the 4th. So there are 4 different days there, but there are 19 charges listed. Each one is misuse of a wireless 911 system, 4th offense. The affidavit.
Buddy, they wanted me to see my girlfriend. I want to marry her. And we did nothing wrong.
Don't say anything. What I want you to do is talk with your attorney rather than saying anything in court today concerning these matters. The charges each have a bond of $100 according to this warrant. The judge that signed the warrant found probable cause and set the total bond at 19 times 100 being $1,900. $1,900 is your total bond for that charge. You have an additional case, and it's an arrest affidavit from yesterday at 11734 East Colonial Drive. The charge is trespass in a structure. The bond on that case is $250. So your total bond appears to me to be $2,150. And there will be a additional condition of no return to the Wendy's at 11734 East Colonial Drive while this case is pending. Nor are you to have any contact with anyone that's named or referred to in the narrative of the arrest affidavit. You have the public defender appointed to represent you on each of those matters.
Well, can I get out on pre-trial release then? Please. I'm in love. She's in love with me. They won't let us together. We did nothing wrong, me and her. I never had no problem with her. Could you help me, please?
What is the state's position concerning the request of release without having to post bond?
What's that?
There is an additional problem that'll have to be addressed before we get into that. It indicates here that Mr. Brown has 3 earlier cases for which he had been bonded. The first case is in Division 83, 9 counts of false 911 calls, represented by
You want me and my girlfriend want to get married, they won't let us together.
Don't say anything at this point.
Okay.
This is a case 2019 MM 9247, 9 counts of false 911 calls from August the 24th, bonded the following day on a bond of $3,700. The next case is trespass in an occupied structure from August the 23rd, bonded on 8/25, Division 62, 2019 MM 6116AO, bond was $1,500. The third charge, driving while license suspended for financial responsibility, Division 80. The arrest was August the 2nd, 2019, bonded on 8/25. The attorney's name is Andrew Darling. The bond is $250. Based upon the fact that I note those prior cases, the bond that has been set on the new charges will remain in effect, and you'll have to post bond on those cases. The public defender does represent you in county court, in circuit court Division 12, and in county court on the trespassing charge.
Hey, Your Honor, you know the government, they tried killing me here.
Okay, stop.
Give me a break, please.
Is the state asking for any action on the prior cases?
No, Your Honor.
All right, no action taken on the prior cases. Those prior cases are not holding him. He will have to post, though, the sum of $2,150 to gain his release on the new charges.
How much is my bond?
This
then?
one, 2,000. Right there.
How much do I need?
How much, $300?
Neville O'Neill Rowe.
Yes, Your Honor.
This is an arrest affidavit from yesterday. It is for a city ordinance violation at Central and Roslyn. That would be the intersection that has the library on the northwest corner of that intersection. The charge is open container of alcohol. It is against the law in almost all cities in the United States to have an open container of alcohol. The bond is set at $250. The public defender represents you in case number 19MO1933. The state attorney's office, on behalf of the city of Orlando, may have an offer to resolve this case at first appearances today.
Yes, Your Honor. Adjudication of guilt, 3 days with credit time served, court cost. That's all.
All right, I want you to talk it over with your attorney as to what's best for you.
I don't have my glasses, I don't know. I don't have my glasses.
Your Honor, Mr. Rowe is interested in possibly accepting the state's offer. The state, I did discuss with the state the possibility of a withhold of adjudication, and the state's amenable to that, but Mr. Rowe, I just learned, had not had an opportunity to review the plea form. Can we skip over his case to give him time to review the plea form and maybe bring him up later?
All right, we can return to that.
Thank you, I apologize.
Move it.
All right, I'm gonna give you a chance to read the plea form. It's important that you read the plea form. Okay. No, he doesn't have a copy.
And I have no problem with that offer. The prior, it indicates he has no prior record and has served in the service. This is, or the next case is Saniqua Toombs. Oh, okay. I stand corrected. Neville Rowe. Is this Neville Rowe?
We just passed over Mr.
Okay.
Rowe.
Saniqua Toombs is the next one. This one?
Go ahead, Mr.
Saniqua Toombs. This is a charge of trespass after warning. It's a first-degree misdemeanor from 655 North Alafaya Trail from yesterday. The public defender does represent her. That is a Five Guys restaurant. There may be an offer to resolve this case at first appearances from the state.
Yes, Your Honor. Adjudication of guilt, 2 days with credit time served, court costs, no return to the scene of the trespass.
She'll accept the state's offer, Your Honor.
I can't do nothing with, okay.
What is your full legal name?
Saniqua Talisha Toombs,
And what is your date of birth?
9477.
All right. The charge that is holding you today is an arrest that took place yesterday at the Five Guys at Waterford Lakes shopping area. How do you plead to that charge?
No contest.
Did you have an opportunity to talk over with your attorney, the public defender, your options today, that you could either bond out or enter a plea? Did you have enough time to talk
Yeah.
with your attorney? Did you read and understand your plea form?
Mm-hmm.
Do you have any questions you want to ask me about this case?
So I get out today, right?
Yes.
All right, that's cool then.
If you tell me that you're willing to stay away from that area,
Can I ask a question?
ask your attorney first, and then
Okay.
we'll see. Okay. Any questions for me?
No?
All right. I accept the plea at this time. You're adjudicated guilty of a first-degree misdemeanor trespass on property after a warning. The sentence is 2 days, credit for 2 days. You'll be released today. Your court costs must be paid in the next 360 days. I order you not to return to the Waterford Lakes Shopping Center and its parking lot during the next 350 days.
Is it Five Guys? It's the whole thing.
The reason for the arrest was it is alleged that you have been trespassed permanently by that shopping center and that this Five Guys restaurant is a part of that property, and therefore you violated the trespass warning. And so even though you may disagree with that, you need to be aware that if they see you, they're going to call the sheriff and you'll be right back here. So if there is some situation that you need to resolve, you need to do it in a legal way by making contact, perhaps in writing, with the Waterford Lakes Shopping Center to see if that could be removed or narrowed or something else. But all I can tell you is that right now, you do not want to go onto that property because it'll just put you back in jail.
Copy plan.
All right?
Okay, we get it. We playing some
All
more. Because I was going to the loony bin, then they decided to take me to jail. We're gonna take you to the place. No, we're gonna take you to jail.
This is Jesus Muniz Rosa. This is an arrest affidavit from yesterday from 1048 Aspen Way in Apopka. It's the Apopka Police Department. It is 3 counts of using 911 in a false call. It indicates that each...
It's not gonna stop for a while.
Okay.
I stand corrected.
Each of these 3 charges now has a bond of $500 each for a total of $1,500. I find that under our rules, the counts 2 and 3 should be bonds of $100. The bonds then are $500, $100, and $100 for a total of $700 bond for Mr. Muniz Rosa. The public defender is appointed to represent him on those charges. Oh, wait. Oh. Is there an offer for him?
Not
at this time.
All right. You can now bond out, but stay in touch with your attorney.
I'm sorry?
You can now bond out on a $700 bond, but stay in touch with your attorney, so you know when to go to court next. Do you want to take a recess until that stops?
That probably is a good idea.
We can take a short recess. We'll find out what the situation is.
Wait till the noise stops.
See, the Quan White, that was a probable cause challenge in my pile. Did they move that to courtroom, the other courtroom too? Yeah, it's okay.
It's loudest in here. So we'll see where else it's probably quieter.
You want me to give you all the stuff I have on that while we're waiting?
I can afford to do some of my hair.
This is the supplemental page
I'm already
for-
10% debt.
This is the garage, and then there's also, that goes with the supplement. And then this is, from one of the store owners. And then this all on the stock.
What was your argument yesterday?
It was more based on the stock that, from the memo I received, it was more like, what was the justification to stopping originally, from my understanding.
You mean the headlong light?
Right.
I'm familiar with the law, but at least the case law reversion. I don't even know why that came up, to be honest with you.
Yeah, I don't know what happened either, but we just wanted to get the supplement. I wonder if your guy read his, plea form, the one guy, the military guy who wanted to read the,
Oh, I hope you did.
get him finalized. I wonder what in the world is going on. So
I meant to ask.
Man, why you calling 911 to get married to his girlfriend?
I don't know.
What girlfriend work at? Is it Wendy's or
Oh,
is it
no.
911?
Do she work at 911?
You seem to be calling 911 a lot.
Oh, so we ain't do nothing wrong.
Say, help me out, Yana.
I don't want
Man
to get
said,
married.
help me out. I love her. Man.
So you call 911 to help.
All right, this is courtroom 1. Monday, December the 9th, 2019, Judge Corcoran presiding. We're back on the first session, and the case next to be reviewed is Stephen Craig Evern. This is a felony charge of driving while license revoked as a habitual traffic offender. It is from yesterday. The arrest was at 1801 North Goldenrod Road. The public defender is appointed. It is Division 22, and the case number is 19 CF 16804-0. The case is complicated by the fact that he has a driving while license suspended with 2 priors. Arrest August the 14th of 2019, bonded out the same day, $2,500 bond. In Division 16, that's case number 2019 CF 11552-AO. When that occurs, I am to revoke the bond in that case and set a new bond. Your new bond on that prior case, 2019 CF 11552, is now $5,000. So the total amount to secure your release on these cases comes to $7,500. You have the public defender on both cases at this time. There's also a reference to an Alachua County case that I'm not familiar with, but it does indicate it indicates there's a writ from Alachua County. Is that also holding him?
Yes.
All right. So you need to be aware of that.
Thank you. Come on.
And is this Neville Rowe yet?
Oh, wait, we'll step back one. Go ahead, Mr. Rowe. Okay, don't worry.
All right. This is Neville Rowe. We're returning to his case, which is an open container city ordinance case. And the offer by the city is a withhold and time served. And Mr. Rowe is represented by the public defender. And what is Mr. Rowe's decision today concerning his options?
He's going to accept the state's offer, Your Honor.
All right. The charge before me today is a city ordinance violation. It's the same kind of case, same kind of ordinance that's involved in every city and town in the United States about having an open container of alcohol. It's not allowed. To that charge of open beverage, alcoholic beverage in an open container, how do you plead?
No contest, Your Honor.
And what is your full legal name
Neville O'Neill Rowe,
and your date of birth?
January 12th, 1959.
All right. Did you have an opportunity now to read and understand your plea form?
Yes, Your Honor.
Do you have any questions you want to ask me about this case?
No, Your Honor.
Did you have enough time to discuss your options with the public defender?
Yes, Your Honor.
Any questions today about this case?
No, Your Honor.
All right. And you understand that the law doesn't say it's against the law to drink, just it has to be indoors or away from public areas such as sidewalks, streets, parking lots, and so on.
Yes, Your Honor.
All right. I accept the plea. I'm withholding adjudication. I note that you have no convictions and that you have served your country in the armed services. The sentence is 2 days, credit for 2 days. You'll be released later on today. And your court costs will go into a civil judgment. It means once you are released, you have no further connection with the court.
Thank you, Your Honor.
Okay, good luck, sir.
Denario Antoine Holmes.
Yes, sir.
This arrest affidavit is from yesterday at 7301 South Orange Blossom Trail. That's in the vicinity of Jordan Avenue and South Orange Blossom Trail. There are 4 charges. Count 1 is trafficking in controlled substance. It has a bond of $100,000. That bond at first appearances is based upon the minimum mandatory fine if a conviction occurs on that under that statute subsection. Count 2, possession of a controlled substance with intent to sell, a felony having a bond of $150. Counts 3 and 4 are misdemeanors, possession of cannabis and possession of drug paraphernalia. So the total bond is $100,350, 100,350. The public defender is appointed to represent you in Division 10 on this case. And a notice of invocation of constitutional rights has been filed. This notice of constitutional rights, I believe, was signed by the wrong person. No, it is correct, all right? And so you can now bond out. Stay in touch with your attorney.
Your Honor, Mr. Holmes knows that he cannot financially reach the bond on count number 1. Would the court consider lowering it some?
My understanding of my position at first appearances is that would not be appropriate. He will need to, in Division 10, move for a bond reduction, and the judge can take into consideration a period of time that convinces the judge that he cannot meet that. But there's, at first appearances, I am not to lower one of those type of bonds due to apparent inability, although clearly if he qualifies for the public defender, it's unlikely. On the other hand, by experience, I know that many of these cases do bond out even though they qualify for the public defender. I mean, they qualify at first appearances. When they do bond out, then they will no longer qualify.
Okay.
This is John, this is Hedrich John.
Yes, sir.
It is a pair of arrest affidavits. The first is a felony affidavit. It has an arrest yesterday, but it refers to an incident on December the 8th. At the CVS Pharmacy, 5300 South John Young Parkway. Count 1 is possession of cocaine, $1,000 bond. Count 2, introduction of contraband into a state facility, $150, a felony. And attempted destruction of evidence, a misdemeanor, $100 bond. The total bond, $1,250 from that affidavit. The public defender is appointed in Division 12 for that case, and that is JMD.
Judge Harris, Division 12.
All right. And then the second arrest affidavit has 2 counts. And it has the same narrative. And so under our rules, count 1, a misdemeanor charge of trespass on property after warning is a first-degree misdemeanor, and it will have a bond of $100. Count 2, resisting an officer without violence, a first-degree misdemeanor, it will have a bond of $100. So the total bond for the 5 charges, $1,450, $1,450 on 5 charges, and that is Division A for that affidavit. Public defender represents you on all of those matters. And there will be a no return, a requirement of no return to the CVS Pharmacy at 5300 South John Young Parkway while the case is pending. The next case before me is Blazier Wecken Kid. It's a warrant from Division 19. It refers to an incident on or about May the 7th of 2019. Count 1, grand theft, 3rd degree. Bond, $3,500. Count 2, use of anti-shoplifting or inventory control device, bond $2,000. Total bond is $5,500. May be modified by first appearance judge. Elizabeth Starr has found probable cause, and so that is not in question. The only matter that's in question has to do with counsel. I do find that you qualify for the public defender, and I appoint the public defender to represent you in Division 19. The bond that's appropriate for these charges are $3,500 for count 1, $150 for count 2. Total is $3,650. There is a further complication in this case. It indicates that Mr. Kidd was out on release from June the 5th from an arrest on May the 20th of 2019. Let me go back and find out. Let's see, May the 7th is the date of this event, which precedes that. And so I find that he is not to be held on that prior case because this is a subsequent matter. So he's no longer being held on that. So your total bond is $3,650. There is an information already filed on that case, on that affidavit.
Go ahead, Mr. Kidd.
So it is simply the announcement of the beginning of the case. In other words, you've been arrested on an information already filed against you. And so my advice is not to say anything other than to talk with your attorney about it.
Yes, sir. Can you please go ahead and revoke all, I'm in DOC right now, so if you want to revoke all my bonds, that'd be great.
I can't do that.
Can the state do that?
Well, unless the state is asking me to do that. That's something you can discuss.
I just would like all my bonds revoked, please. She's never heard that from an inmate. I guess you don't get that question all the time.
Well, it has to do with whether you get the time from the state.
Correct, that is.
Yes, sir.
Correctional institution.
We could agree to that, Your Honor.
You do or don't?
We could agree to that.
Thank
All
you. Thank you, ma'am.
I will at this time then, based upon that understanding, the release on the grand theft case is revoked at this time, and you are held without bond on case number 2019 CF 6577. It's Division 16. It indicates your attorney is Patricia Cashman. That's a public defender. You can talk to that person, and if you, after talking with that person, change your mind, you can always request a hearing to have the judge in Division 16 set new conditions of release.
That's fine, sir. Thank you.
Michael Sean Mackey? This is an arrest affidavit from yesterday. I appoint the public defender to represent you in Division 10. The case number is 19 CF 16806-0. It's from Pennsylvania Street and South Orange Avenue. It's from the city of Orlando. There are 4 charges. Count 1 is a felony charge of burglary of an occupied dwelling. It has a bond of $5,000. Count 2 is burglary of a conveyance, bond $150. Count 3, possession of cocaine, bond $150. So those 3 felonies have a total bond of $5,300. There's a misdemeanor charge of possession of drug paraphernalia, bond $100. So the total bond is $5,400. It will also have a no return The case is complicated by the following. There is a charge in Division 11, the charge of burglary of a conveyance, arrest date August the 14th of 2019, bonded out on November the 17th. Public defender represents Mr. Mackey, 2019 CF 11587AO. At this time, I revoke the bond in that case. You are held without bond, Mr. Mackey, until you obtain a hearing in front of the judge in Division 11. That judge will have the opportunity to review the file of that first case, as well as the new charges, and that judge can either hold you without bond or can set new conditions of release. It will be up to that judge to make that decision. I'm simply revoking and holding you until that hearing is held. You have bond on the other charges. Nicole May Machad.
Yes.
This is a charge of petty theft, but with 2 prior convictions, so it is charged as a felony charge from yesterday at 8574 South Orange Blossom Trail. That is a Wawa gasoline and convenience store. The bond is $1,000. The public defender represents you in Division 12. You can now bond out on a $1,000 bond with a no return to the store at 8574 South Orange Blossom Trail while this case is pending.
Okay.
Rashawn Richardson.
Yes, sir.
This is a case from yesterday at 43rd Street in South Nashville. Count 1 is a felony possession of cocaine having a bond of $1,000. Count 2 is possession of meth having a bond of $1,000. Count 3 is a charge of possession of drug paraphernalia having a bond of $500. The appropriate bonds on the case are set by me today. I modify those amounts that are shown on the arrest affidavit itself. Count 1 is a bond of $150. Count 2 remains a bond of $1,000. Count 3 becomes a bond of $100. So your total bond from yesterday, $1,250. I appoint the public defender to represent you in Division 14. Your case is complicated by the fact that you had been previously released on October the 17th in Division 12 on the charges of possession of meth, possession of drug paraphernalia, and resisting an officer without violence. Case number 2019 CF 14552. I find that I am to revoke the bond on that prior case, and you are held without bond until you see the judge in Division 12, case number 2019 CF 14552. And I recognize that none of these cases are crimes of violence. However, the possession of methamphetamine is a charge that warrants a no bond when it's a repeat, until that judge has an opportunity to review both cases and decide whether you should have new conditions of release or held until the cases are resolved. This is Joseph W. Staggs. Yes, sir. This is an arrest affidavit from yesterday. It comes from 11639 East Colonial Drive, number 217. It is a Days Inn motel. Count 1 is possession of meth, having a bond of $1,000. Count 2, possession of drug paraphernalia, having a bond of $500. Count 3, possession of ammunition or electric weapon by a convicted felon, having a bond of $5,000. Under our rules of setting bond at first appearances, count 1 will now have a bond of $150. Count 2 has a bond of $100. The total bond then is $52.50. And the public defender is appointed to represent you in Division 415. The case is complicated by a number of prior matters that will have to be reviewed at this time. There are 4 cases. The first is 2019 CF 16017. The public defender is appointed to represent you, or you're already represented the public defender, but I will appoint the public defender out of an abundance of caution. It indicates that you already have the public defender. Count 1, grand theft, 3rd degree. Count 2, possession of meth. Division 22, and I revoke the bond in that case. You're held without bond till you see the judge in Division 22. The second case of a prior matter, November the 19th, bonded out on November the 28th, 2019 CF 15830, burglary of a conveyance and petty theft with 2 priors. That is Division 12. I revoke the bond in that case, and you are held without bond till you see the judge in Division 12. The next case is 2019 CF 15825 AO. Also an arrest on the 19th of November with a bond of November the 28th. Public defender, count 1 is burglary of a conveyance and count 2 petty theft of $100 or more. I revoke the bond in those cases. You're held without bond till you see the judge in Division 16. The fourth and final prior matter is in Division 20. You have the public defender in case number 2019 CF 13030. Same dates. Division 20, grand theft, 3rd degree is count 1. Count 2, possession of meth. Count 3, misdemeanor, ROR, and possession of cannabis. And count 4, misdemeanor, possession of drug paraphernalia, ROR. Counts 2, 3, and 4 were RORs. There was a $2,000 bond on the first count. Though that release is revoked at this time, you're held without bond on all 4 cases until you see the judge in each case. That judge can decide whether to set new conditions of release. In the meantime, you can bond out on the new case, but as a practical matter, until you resolve the first 4 and or see the judge and have new conditions set, you are being held in jail until the cases are resolved. Yes, count 3 on that, on the new charges from yesterday. Count 3 is stayed at $5,000. That's the correct bond for that particular charge. Although I had the feeling that $4,000 is the amount of bond on a possession of ammunition by a convicted felon. I believe it's $4,000. So I do change that from $5,000 to $4,000. It's a minor change, but it is the correct amount. Your total bond on the new charges come to $42.50. This is Edsel Walter Kaiser.
Yes, sir.
This is an arrest affidavit from yesterday at 8225 International Drive. Disorderly conduct at a public establishment. Bond is $500. It is it's a location called Star Flyer, and the event that's the subject of the case was 1 minute before the 8th. The arrest took place on the 8th, but the incident is indicated to be the 7th of December at 23:59, 11:59 p.m. It's in the vicinity of King's Bowling parking lot and Star Flyer area on International Drive. The public defender is appointed to represent you on this misdemeanor, but it's complicated by prior cases. The prior cases are all misdemeanors: no motorcycle license, expired tag, and driving while license suspended. The state can be heard if you are asking for any action on the prior cases, or whether the new case is capable of being resolved at first appearances.
Your Honor, no requests on action on the priors. On the present case, our offer would be adjudication of guilt, 4 days, credit time served, court costs, no return to the scene of the disorderly conduct.
The offer is 4 days, credit for 2.
Your Honor, he's going to accept the state's offer.
And actually, I stand corrected, he only has 1 day.
We go by the arrest date.
Oh, it's by the arrest date? All right, 4 credit for 2. Means you get out tomorrow.
Okay. Like. Beginning in, I remember.
Right there, Martha. Biden will tell you she knows his office schedules are on here.
And be aware that you still have the other 3
Cases.
pending. What's your full legal name?
Edsel Walter Kaiser,
Date of birth?
6/13/1975.
The charges, misdemeanor charges, disorderly conduct at a public establishment from yesterday at 8225 International Drive. How do you plead?
Guilty, or no contest.
Did you have enough time to discuss your options with your attorney?
Yeah.
Or do you need more time? I don't want you to feel like you've been rushed into a decision.
No, I feel I'm fine.
All right. And did you read and understand your plea form?
Yes, I did.
Any questions you want to ask me concerning the charge, the facts of the case, the plea that you're entering, or the proposed sentence?
No, I think I heard everything.
Are you willing to stay away from that location?
Yes.
Okay. I'll accept the plea at this time. You're adjudicated guilty, and the sentence is 4 days, credit for 2. No return to within 500 feet of 8265 International Drive during the next 179 days. Your court costs are payable within 360 days from today. So you'll be released tomorrow.
Okay. Thank you.
Savan Dassey?
No.
Either one of these, Devon Sassy?
No, Your Honor, he'll be next.
Okay, we'll come to that. Who is before me at this time?
Trevante White, sir.
Thank you. This is a charge from Orlando Police Department, 2421 Betty Street, from yesterday. Loitering or prowling, bond of $250. It is a state charge, though, and the problem that causes is there's an on-view, on-site violation of probation for probation in Seminole County that holds him without bond. Seminole County will have an obligation to pick you up within 24 hours after the resolution of your Orange County case. That probation has a scheduled termination date of June the 17th of 2022, so I find jurisdiction to hold you. The original sentence, November the 19th of 2018 in Seminole County for burglary of an unoccupied dwelling, 3 years of supervision. The public defender is appointed to represent you on the new charge in county court. And so the issue is ordinarily, because we can see that there's a connection between the new charge and a violation of a possible violation of Seminole County probation, state probation, but from the county of Seminole, that this case cannot be resolved today. The new case cannot be resolved today.
Yeah, I don't believe that would be in Mr. White's interest.
All right. If you bond out on the new charge, then you'll be immediately taken to Seminole County to see the judge on that case.
Your Honor, this is the last case, Mr. White, and then we'll pull in Dasty after that.
All right. This is Daquan White.
Yes, sir.
This file shows that Mr. White has 4 charges and was seen by Judge Epperson as the duty judge over the weekend. And that judge did appoint the public defender to represent Mr. White and found that there was not probable cause, and the state attorney was given 24 hours to submit a supplemental arrest affidavit. The arrest affidavit shows burglary of an occupied structure, criminal mischief, possession of cannabis, and resisting without violence. 1 felony and 3 misdemeanors. Those charges coming from 2033 Americana Boulevard, which is the area of South Texas and Americana Boulevard. And is there a supplemental document having to do with probable cause?
Yes, Your Honor.
All right.
I've previously shown the information to the public defender. I don't know if you would like a copy or just...
Do you have a copy?
I don't. I did have an opportunity to review all the documents, though.
All right. Thank you. From the, who wishes to go first on this matter?
Your Honor, we have no further opposition to the matter of probable cause.
All right.
If that helps.
Okay. And therefore, the matter is that Mr. White can now bond out on a total of $5,300.
Your Honor, he also qualifies for release to PTR. Would the court consider release to PTR in lieu of bond? Or monetary bond, I should say.
See what the state's position is concerning that issue.
Our records do show that he qualifies for PTR.
Does he qualify for pretrial release?
Yes, Your Honor, he does.
And what is your position concerning pretrial release?
We could agree to pretrial release.
All right. At this time, then, the cases are assigned to Judge Barber in Division 16, and Daquan White will be released on these 4 charges on pretrial release, and you will have the responsibility not to return while this case is pending to within 1,000 feet of the Food Lotto store, 2060 Americana Boulevard, while this case is pending, nor have any contact with anyone that is named or referred to. Also, not to go within 1,000 feet of the business at 2048 Americana Boulevard, nor the within 1,000 feet of the Amscott located at 2033 Americana Boulevard. Those areas are off limits to you while this case is pending, nor have any contact with anyone that's named or referred to as a victim or witness to the events that are the subject of these 4 charges. Okay. But you are now released on pretrial release. It's your responsibility to find out what their rules are and stay in touch as the pretrial release people require you to do.
I'm sorry about that, sir. Yes, sir.
You'll need to stay in touch with them and your own attorney, public defender. Don't say anything more about that, though. Do you need for me to physically write on their pretrial release on this? Good morning.
Good morning, Your Honor. Roger Weed here on behalf of Siobhan Dassey.
All right. This is a first appearance. It indicates that Mr. Dassey could not be seen on the weekend due to hospital.
Yes, sir. He was hospitalized for 3 weeks.
Yes, I was the judge back at the time of his arrest, that particular day. The charge before me today is attempted first-degree murder with a firearm. It's a no-bond charge, and it is from November the 17th, 2019, at 5197 Lynette Street. And you are the attorney for Mr. Dassey at this time?
Yes, Your Honor. I have filed a motion to set bond for him, arguing that the proof of guilt is not evident, nor is the presumption of guilt great.
All right. Do we have did you say that you filed a written motion?
Yes, sir. It was e-filed a couple weeks ago.
All right, we'll see if we can locate that. Does the state have a copy of that?
I don't, Your Honor.
Okay, we'll see if we can print off some copies of that. In the meantime, would you like to proceed with the argument today?
Yes, Your Honor. As the charge affidavit indicates, Mr. Dassey had a right to be where he was. This was at a residence in Orlando. He was with a couple of friends, and the alleged victim had come there and accosted Mr. Dassey's friend and hit him with a pistol, knocked him out. Gunfire was exchanged. Mr. Dassey was shot 3 times by this individual. Mr. Dassey was trying to defend his friend at the time. So he has a very viable argument for self-defense, and I think for even having a stand your ground motion. He's a longtime resident of Central Florida, has no prior record.
Okay, here's a copy of the motion for the state. It is a motion to set reasonable conditions of release and raises the issue of whether Mr. Dassey can be held, whether it is required that he be held, and to do so, the state would need to be in a position to respond on the basis of whether the state can show that the proof's evident and the presumption is great to hold him on an attempted first-degree murder with a firearm, or whether the state will be setting conditions of release.
Yes, Your Honor. In this case, Jasmine Keene and her boyfriend Trey Holt were going to the stated residence to pick up her children that she shares with Javian Hunt. And once they were there, Holt and Hunt got into a physical altercation. And at that time, the defendant and another stepped out of the vehicle and approached Jasmine Keene and her boyfriend, pointing firearms at them. The boyfriend then pulled out his firearm and fired at Dassey, striking him in the stomach. And then they began to retreat to their vehicle. Dassey and Humphrey continued firing at them. They got back in their vehicle and they drove off where they flagged down officers. During the exchange of gunfire, she was struck in the arm. The police officers were able to go to the neighbor's house across the street that had surveillance camera, and it captured the incident, which was reviewed by law enforcement. And the footage showed that Keene and her boyfriend were retreating to their vehicle when the 2 subjects, including the defendant, were shooting at them. And based on the fact that the defendant fired when the 2 people were fleeing, the state argues that there is proof evident or presumption great of attempted first-degree murder and asks that the defendant be held without bond.
Response.
Response is, Judge, Mr. Dassey, as they indicated, was shot 3 times before those perpetrators attempted to leave, and clearly he shot 3 times. He's not the one that was firing back. There's another individual that was there that was firing back. In any event, even looking at the presentation by the state, it doesn't meet the standard of proof evident presumption guilt great, because as you know, that's higher than beyond a reasonable doubt. It almost requires a degree of moral certainty, and I don't think that their recitation of those facts they purport rise to that level, so Mr. Dassey should be entitled to a bond in this case.
All right. I find that the state is unable to meet. This is the second session in courtroom 1 for Monday, December the 9th, 2019. Judge Cochran presiding. There are 3 cases that will be reviewed in which the person has requested an interpreter. And do we have the Spanish interpreter? Who is it that we have here? Abreu?
Joel.
It's the first case on the felony docket. No, we could start with these cases and then maybe just leave the translator cases for last.
We'll return to Mr. Abreu as soon as we have the interpreter online.
This is the interpreter. Can you hear me?
Yes, thank you. Have you been sworn?
Yes, sir. Jaime Sotomayor, certified federal interpreter, already sworn.
Thank you. I'm Judge Kirkland. I'm reviewing 3 cases. Each of these 3 persons have requested a Spanish interpreter. And the first case is Joel Antonio Abreu. I'm Judge Kirkland reviewing his case at first appearances in courtroom 1, Monday, December the 9th. There is a capias before me. Mr. Abreu has the public defender in Division 22. That capias tells me that an information has been filed against Mr. Abreu on the charge of possession of cocaine. And the capias was issued by the judge in Division 22 for failure to appear for a case management conference on November the 13th. And that judge set the new bond at $2,500. You are represented by the public defender, Mr. Abreu, and you can now bond out. And it is important for you to stay in touch with your attorney and know when your next hearing is so that you do not get rearrested for failure to appear for any hearing in Division 22. That case number for the court interpreter is 2019 CF 9511AO.
9511?
2019 CF 9511AO.
Thank you, sir.
The next case will be Giselle Camacho. She is listed as an English speaker, but she has requested the assistance of the Spanish interpreter. It is case number, her name is Giselle Camacho. It is case number 2019 CF 16780. I'm sorry, it's 16780AO. The public defender is appointed to represent Ms. Camacho in Division 10 on the charge of aggravated battery. Her bond is $3,500, and I appoint the Public Defender Division 10. You can now bond out with the following conditions: not to return to 10201 East Colonial Drive while the case is pending, not to have any contact with the person that is listed as the victim or witness in this case,
Can I ask something?
What was the question?
Yo no entiendo por qué me acusaron a mí si la que fui agravada fui yo.
I don't understand why I was the one who was charged if I was the one assaulted.
There was there's no discussion.
You will need to talk with your public defender about the defenses to the case. I find, based upon the allegations contained in the narrative, that Ms. Camacho is to be held. In reviewing the facts of the narrative in the arrest affidavit, I do change the bond from $3,500 to $1,500 as being appropriate for the allegations. The charge, though, is a serious felony entitled aggravated battery. No contact with that person, nor no return to that location while the case is pending. Stay in touch with your attorney so that you know when your next hearing is scheduled in Division 10.
Okay,
The 1,500, can it be 10%?
That is something that you can talk with your attorney about, and that is depends upon whether a bail bondsman posts the bond on your behalf. It is, generally speaking, is ordinarily 10%.
Otra cosa, yo dejé mis documentos, mi residencia, tuve que salir corriendo del lugar porque me estaba golpeando.
Another question, I left my documents and my residence because he was beating me. I had to run away. I left my purse, I left everything.
I have my resident alien, my social security, my ID, everything there. That's what I'm really worried he's going to throw them away because I need those documents to apply for a job or for everything. So how I'm going to get my stuff back? Because I had to run. I was the one that pulled over the police because I was asking for her. Arrested me.
Would you authorize a one-time return to recover her personal effects?
Yes. There can be one-time return with a deputy to get clothing, personal effects, tools, motor vehicle, anything that is clearly belonging to you rather than any other resident of that location.
I hope he didn't throw them away. I need my resident alien. Thank you.
The third case for which there has been a request for interpreter is Luis Raul Sierra Castillo. It is a case from Osceola County, case number 19CT2446. There is a change.
I'm sorry, Your Honor. I couldn't hear the case number because they were moving the headphones.
Yes. The case number in Osceola County, here in the 9th Judicial Circuit, it's case number 19CT2446. It's a failure to appear on a driving while license suspended charge. And the warrant arrest affidavit states that there's a particular statute, and that has been corrected from the original statute. The correct statute is 843.151B, and that's what that arrest affidavit now says. And looking at the paperwork from Osceola County, it indicates no bond until you see the judge there in Osceola County. And if he has no local Orange County cases, he'll be transported there generally within 24 hours to see that judge on the pretrial conference for driving while license suspended. All right, that concludes the interpreter cases for this courtroom. My understanding is that there will be interpreter cases in courtroom 2 this afternoon. Those are domestic cases to be heard later on this afternoon.
No problem, Your Honor. Have a good rest of the day.
Thank you, you too. This is Jean Thomas Dubuisson.
Yes, sir.
It is an arrest affidavit from yesterday at 2401 South Rio Grande. It is a felony charge of possession of Xanax. The public defender is appointed to represent you in Division 19. You can now bond out on a bond of $1,000. The condition of release for the bond is not to be in possession of any substance prohibited by law or any prescription medicine without having a prescription for it.
And he did qualify for PTR, Your Honor.
Any objection by the state to a pretrial release? Okay, you'll need to talk with your public defender right now as to whether you would rather post a bond of $1,000 or, in the alternative, be released on pretrial release and have the obligation to remain free, connected with pretrial release program.
Your Honor, he'll accept release to PTR.
All right. At this time, then, Mr. Dubuisson is released on pretrial release. Make sure that you become aware of their requirements and that you report as they require, because a failure to abide by pretrial release rules would put you back in jail.
Thank you, sir. Can't be, because they would have told you. Yeah, they would have told you. You wouldn't be here.
Okay. Gustavo Jose Figueredo Pereira. There are two affidavits. One is a driving while under the influence from a uniform traffic citation. It is a $500 bond, is from East 6th Street in Windermere. Public defender is appointed to represent you in that case. Division A, case number is 19 CT 2404 AW. The second arrest affidavit has a charge of escape, which carries a no bond, resisting an officer without violence, a $500 bond. The public defender represents you on those two charges.
And he does qualify for PTR, Your Honor.
All right. I do not I don't believe I am to release someone that is charged with escape on pretrial release. On the other hand, my review of the facts in the case indicate to me that he should have conditions of release and not to be held as a no bond case based upon those allegations. Or the state can be heard with regard to that very issue.
Defer to the court's discretion.
It appears to me that the facts alleged are that he did slip out of the handcuffs, but he was always within a holding cell.
Your Honor, I did want to highlight that and ask that you consider releasing him to PTR. I don't think in the end the state's going to charge the escape count.
In my review of the case, I believe the following would be appropriate. On the escape charge, I find that there's no probable cause, and that's an ROR on that case. The other two charges, though, driving while under the influence has a bond of $500. The resisting an officer without violence has a bond of $100. He will have to post a $600 bond to secure his release. On those two charges, they are, in that second affidavit, they are in Division 11. And I believe I am still to keep him in Division 11. It's up to that judge. That judge may, or the state may elect to have those both placed in a misdemeanor division, or they may decide they want to proceed on that charge of escape, notwithstanding my decision today. But your bond is $600, and you have the public defender on all charges. He apparently had a job as a magician before. This is Christian Rafael Gonzalez. Thank you. Peter Hackett Jr. This is an affidavit that comes from a Florida Uniform Traffic Citation. The first count is fleeing or attempting to elude. It comes to me as a no bond. Count 2 is no valid driver's license. Count 3 is resisting without violence. Those are all, counts 2 and 3 are misdemeanors, and they will have bonds of $100 each. The first count is properly brought to me as a no bond, but I am to set the conditions of release today. The statute lays out the matters to be considered at this time, and they are, was he driving a vehicle, motor vehicle? Did he endanger himself or passengers or pedestrians or other drivers? Was there a crash? Were there injuries? Did he have excessively high speed or run red lights or stop signs? Was there a crash? Was he escaping a more serious charge? And finally, has he been convicted in the past of fleeing? And has what generally is his prior record? So the state can be heard as to what is being requested in the way of conditions of release. I note that he has no adult convictions with many juveniles. And I can consider anything at first appearances as far as setting conditions of release.
Just a moment, Your Honor.
All right. Is there a hold from Lake County would be one question.
Yes, there is, Your Honor.
There's a reference to Leesburg
Yes.
matter. And is that a no bond, the Leesburg?
No, it's a $60,000 bond.
1/6?
60,000.
60,000.
60,000.
Okay.
Previous record is noted by the court, and I do note that he was up to 93 miles per hour, and apparently at one time even the sheriff's office helicopter was involved in trying to locate him and so forth during the pursuit. So I would ask the court to consider those things and then defer the court's discretion in setting bond.
Based upon the allegations contained in the narrative alone, the appropriate bond is $5,000, and I note that there's a hold for Lake County for $60,000. So that's a factor in all of this. He does have the public defender on these 3 charges from yesterday in Division 12.
Your Honor, are the remaining bonds 100, 100? The subsidiary
Yes,
bonds?
yes.
Okay.
Total bond from Orange County, $5,200. Germany, Rashad Jones.
Good morning, sir.
All right. There are 4 charges here from yesterday, from early this morning at Grove Park and Park Lake Circle in Maitland. Count 1 is possession of cocaine, bond $1,000.
And cocaine.
Count 2, possession of controlled substance without a prescription. The appropriate bond in that case is set at $150. Count 3, possession of marijuana over 20 grams. The
Your Honor, this is
appropriate bond
Mr. Jones.
Yes, this-
Oh, I
This is
do
Germany
have the wrong
Jones.
one.
Marcus Hall and bond, Your Honor.
Okay. He's already bonded. All right. Mr. Jones has 3 charges before me from earlier this morning at 1515 Worst Road. Count 1 is possession of heroin. Bond is $1,000. Count 2 is a misdemeanor, resisting without violence. $100 is the appropriate bond. And count 3, resisting with violence, a felony. Bond is $150. Total bond is $1,250. No contact with anyone that's named or referred to as a victim, witness, or arresting officer. It's from the city of Ocoee, but these are 3 state charges. No return to the parking lot of the Circle K at 1515 Worst Road while the case is pending. The public defender represents you, Mr. Jones, in Division 20. Rudyard James Lally. Thank you. Bernard Poitier. Thank you. Brandon Singh. This is an affidavit from earlier this morning. Count 1 is a fleeing charge. A felony charge comes to me as a no bond, but I'll be setting the conditions of release today. Count 2 is a felony charge of participating in an unlawful race. The charges come from 11505 Satellite Boulevard in unincorporated Orange County. Are you planning to hire a private attorney?
Yes, Your Honor.
All right. The case number in your case, we'll make a note for you because you'll need to communicate that to your attorney. The case for your new charge is 19 CF 16812 AO, and your case is in Division 10. And the judge in Division 10 is? Adams, Judge Adams. There's a complication in your case as follows. It shows that you were out on bond on grand theft 3rd degree in Division 12, and that you have an attorney on that case, and it's from April of 2019, having bonded out on that charge. So there are 2 matters that will be decided by me today. One is what the conditions of release are on the charge of fleeing. And then finally, whether there's action to be taken on the prior case of grand theft 3rd degree. What is the state's request or position concerning the charge of fleeing? What are the conditions of release sought by the state?
Defer to the court's discretion.
All right. I take into consideration, Mr. Singh, the statutory requirements for consideration, and that is, were you driving a motor vehicle? Did you endanger yourself or passengers or pedestrians or other drivers or onlookers? Were you driving at excessive speed? Did you run a red light or run a stop sign? Was there a crash? Were there injuries? Were you fleeing a more serious offense? Have you had prior record? Do you have a prior record of fleeing? And what is your general prior record? I don't see anything much as far as a prior record. The allegations here is that it was a racing situation, and then simply after being directed to get out of the vehicle, you continued driving. It does not show unusual facts concerning the first count, which is the fleeing, it does show unusual facts contained, but that's the second charge, the racing charge contains those. I find that the appropriate conditions of release on count one, $2,500. So your total bond from yesterday, $2,500 plus $100 for a total of $2,600. What is the state's position concerning the prior charge of grand theft for which he was released back in April? All right. And does the state take a position as to what the state, as to what the court would do following the revoking of the bond? New conditions or no bond?
Would defer to the court's discretion.
All right. I find at this time that I am to revoke the bond on the prior case, 2019 CF 5540, in Division 12, the grand theft third degree. I set new bond. The new bond is $2,000. So the total amount that you will have to post in order to get out is $4,600 between the two new charges and the one old charge. But you can bond out. Contact your private attorney concerning these matters.
Okay.
Do we have any more persons?
No more.
Okay, I'll call these cases in. We have Camille, Jacques, Alex Camille, all right. Brandon Lewis. Juliet Romeo. That's a very unusual combination. They decided to name her Juliet with the last name Romeo. Very, very nice. All right. Matthew Chowning.
Bonded.
Thank you. Jean-Pierre Mahum Mazuza. Sadia Raymond.
Bonded.
Christopher Hull.
Also bonded.
Thank you. Any other paperwork for today? Okay, I believe we're in recess. I will be here on Wednesday, but someone else, but I think Judge Wish is here tomorrow, or someone else is. Do you get these?